Good morning, good afternoon. Not legal advice, KNOT. Like, subscribe, share, do all those things. Appreciate it. Thank you for subscribing. Today I'm going to talk about a FINRA arbitration. So I filed my FINRA claim last night. I got a confirmation. I think it's I was looking over here. 6:29 p.m. Pacific time. They received it, and I got some further confirmation later on. So that has been filed. Before I go on, I just was struck by something. Uh, I start off all my videos with a joke, so-called joke. The owner of the Florida Panthers and Virtu Financial, I think he likes short positions, tweeted me that he did not like my jokes, at least as to one of my videos. So, Dougie, you know who you are. This one is for you. Did you hear about the new restaurant on the moon? It has great food, but no atmosphere. Hope you enjoyed that, Dougie. And thanks again to little Bruce T out there. So, I filed my arbitration claim electronically yesterday. And what I'm going to do is, I think I'm going to do this in two parts. So, I'm going to kind of go through what the system is itself and how you can do it. And then I'll go through my actual claim in a second video so it's not ridiculously long. So the first thing I did is I Googled FINRA dispute resolution. That took me to the FINRA site. And then once it took me to that FINRA site, it had the options of both arbitration or mediation. So as to mediation, mediation is a non-binding negotiation led by a neutral third party. If both sides are not fully vested in obtaining an outcome, it's unlikely to work. So, if one side's not really interested in working on a resolution, then it's kind of a waste of time. Since Fidelity has been less than forthcoming in trying to resolve this, I have no interest in mediating it with them. And that's especially the case because you pay for that pleasure. So if you choose to mediate, you do pay for mediating, or you have to pay some fees. You might be able to get those back, by the way, if you prevail in your action. You might be entitled to recover your costs. So that's something to keep in mind. And per your agreement, there also might be a legal fee provision, which might give you the opportunity to obtain your legal fees if you hire counsel. So I elected arbitration. So again, if you look on the site, so now you've gone to that FINRA site that I directed you to, the FINRA dispute resolution site. So you will see the arbitration section, and in the arbitration section, there'll be a link, and if you press the link, it'll show you documents, what documents you'll need to file. So just for familiarity's sake, push the link to get an idea. So go to the FINRA site, go to the arbitration section, push the link that shows you what documents, just so you have an idea. There also will be a portal that you will use. It won't take you to another universe, although maybe it will, but it's used to basically manage your arbitration once you begin. It's called the DR portal. In the DR portal, we will be either the claimants or the customer, and you'll see there be places where you can answer. If you're something different than that, then put that. But it appears that most times, at least with regard to like MMTLP, for example, you'd be a claimant or a customer. Once you start using the DR portal, all future communications and instructions must be through it. If you're not represented by counsel and elect to proceed to arbitration, and just as an aside note, if you start an arbitration, it can be terminated without a resolution. So I think there's been questions that have been asked about what happens if other things happen in other forums and we filed an arbitration. Just be aware that you can terminate an arbitration, dismiss the claims, etc. And again, you should consult an attorney as to that. But again, if you're if you're filing it on behalf of yourself, and then you'd be considered to be a pro se, you can make your initial submission by mail, but everything else would have to be through the DR portal, and they would send you some confirmation through the mail and instructions to go to the DR portal. So you'll see that once you go to the DR portal, you will need to prepare and submit something called a submission agreement, and it's pretty easy to fill out. You'll fill it out online, and you can also have an electronic signature. So it'll give you the opportunity to submit an electronic signature. And you agreed to be bound by the terms of FINRA and their arbitration. Now, just as a side note, in my claim documents, I did assert that FINRA has a conflict of interest and shouldn't be handling this, etc. But notwithstanding that, when you submit the submission agreement, you're agreeing to the terms of the arbitration with FINRA. So you should be familiar with that and review that. Also, when you are preparing and submitting the submission agreement, it will ask you to pay fees and will ask for claim documents. As to the request for fees, it's based on your damage claims. So it's based on how much you're asking for damages. And for example, if you're asking for I think it's up to $500,000 in damages, the approximate filing fee is $1,450. If it's up to $1 million, I think it's approximately $1,750. That's the filing fee. There may be other fees that you incur as you go on. So it's important, if that's a financial hardship, and for most in the MMT crowd, they certainly can make an argument that what has occurred has placed them in that position. When you prepare your submission agreement, you can ask for a fee waiver. So you can literally ask FINRA to waive filing and other fees. In my submissions, I prepared a separate document called a request for fee waiver. I asserted the facts and the large amount of time that I've incurred as a hardship basis. They also ask for supporting documents, W-2s, tax returns, etc., if you want. I personally have no interest in providing those documents to FINRA. I distrust FINRA, and I've asserted their tortious and criminality. So I have no particular interest in providing them sensitive information. But that might be a basis upon which they deny my fee application waiver. So if that happens, so be it. However, I would urge all to, if it applies, to seek a fee waiver, and with not telling you what to do, not legal advice, but there's a higher likelihood of your fee waiver request being granted or partially granted. And as an aside, so they could grant your entire fee waiver, or they could reduce the cost or other, and they could do it on each fee that arises. But my opinion would be there's a higher likelihood of you getting your fee waiver granted if you produce backup financial information showing hardship. But that's your call. So you've now completed your submission agreement. Attach the fee waiver and supporting documents, if any. And again, in the submission agreement, it will be clear where these particular documents should be placed, and you will attach them in the submission agreement, and it will explain how to do that also, but it will be self-explanatory. Then you'll see a place that'll ask you for the claim itself. So I prepared a 7-page document that I called claim, and I referenced my account number at Fidelity, and I attached and incorporated by reference my third amended complaint that I filed in federal court. So I have a 7-page claim document, and I attach my third amended complaint, which is about 30 pages long, and I incorporate the allegations in my third amended complaint as part of my claim. Now, obviously, not all of you have filed lawsuits, so you can't attach your third amended complaint or whatever you filed. So perhaps your claim needs to be more detailed than my 7-page claim. But the statement of claim should touch on the parties, all the salient facts in a chronological order, and the requested damages. If you don't know your exact amount of damages, you can say over a certain amount, over $500,000 and less than $1 million. Or you can say according to proof, but that could impact the amount of fees that you have to pay. So you have to think about it before you do that. Also, you should be aware that if your claim is above, I think it's $100,000, then you go from 1 arbiter to 3 arbiters. And myself personally, I would prefer multiple arbiters as opposed to 1. I'd prefer that a majority would have to rule one way or the other, as opposed to 1 who might rule, I don't know. So once you've completed your basic claim, so you've generated some type of document that lays out your claim, or someone is going to do that for you, then they would submit that as an attachment to the submission agreement. And again, that will be evident too where you do that. It will also ask you for backup documents. And this is just my opinion, my perspective, not legal advice. I'm loathed at this point in time, pre-discovery, to go out of my way to help the other side, especially when they've withheld documents and interactions. That is my view. So for me, until required and mutual, I'm in no hurry to furnish my opposition with something they are withholding from me. However, if you want to do it otherwise, then feel free. Or if your counsel suggests otherwise, feel free. Video's long enough at this point in time. Next video, I will address the actual claims I filed and the next steps. Be well, take care, have a good day.